Flooding is becoming a bigger issue across the UK, with regular storms and increased rainfall compared to previous decades. And it can create more than just disruption, it can also create legal risk. So, if water from your land is ending up on a neighbour's property, or a neighbour says that works you've carried out on your land have made existing runoff or flooding worse, what does the law expect of you? I'll explain the key principles around liability for flood damage, the types of claims that can arise, and the practical steps that can reduce the risk of a dispute. Just a quick disclaimer before I go on. This is general information and not legal advice. Flooding nuisance cases are very fact specific, so if you're dealing with a live issue, get tailored advice early. Flooding can happen for lots of reasons: heavy rainfall, overland flow, blocked drains. But from a legal point of view, the potential claim against a landowner that's allegedly caused flooding is one of nuisance. In general terms, the law of nuisance covers situations where an act or omission by one landowner is damaging, causing substantial interference with the use and enjoyment of neighbouring land. The key question is often, has something been done or not done that's made the position worse? A landowner must not take actions that cause or increase the risk of flooding to neighbouring properties. And the key thing to look out for is whether there's been what's known as a non-natural use of the land. This comes from a rule created by the case of Rylands and Fletcher, which, despite being an old case from 1868, is still a leading authority when it comes to escape of water and flooding. This non-natural use of land can include things like diverting a natural water course, changing land levels, altering drainage, or carrying out building works that change how water moves across land. The courts will often look at whether actions were reasonable and whether adequate steps were taken to mitigate the flood risk. I should say here, we're not just talking about rivers or other large watercourses, for which the responsibility of flooding will often lie with the relevant statutory undertakers and the Environment Agency. Private landowners can still be liable for flooding, depending on the source and the cause, including things like surface water discharge or inadequate drainage systems. If a neighbour believes your land or works carried out on your land has caused or worsened flooding and they take you to court, you're risking an order for two things: an injunction to abate the nuisance, which is a court order requiring you to stop the activity, undo the works, or take specific steps to prevent further flooding, or, and sometimes damages, which is monetary compensation for the loss suffered. When deciding claims, courts may consider things like the extent of the damage caused, whether it was reasonably foreseeable, and what steps were taken to prevent or reduce the risk. Has the landowner done all that it reasonably can be expected to do to mitigate the risk of flooding? If you're a property owner, a landlord, or a developer, a few practical steps can make a real difference. Maintain and inspect your gutters, drains, gullies, and private drainage regularly. Keep records, photos, maintenance logs, invoices, inspection notes, as they can become crucial evidence should things go awry and end up in court. Be careful with flood defences. A wall or barrier that protects your land but redirects water onto a neighbour's land can create a new problem. And if you're developing, take technical advice early in respect of drainage design and surface water discharge consideration. If flooding is affecting a neighbour or a neighbour's blaming you, early action matters. Document what's happening, keep communications measured, and get advice before positions harden. Many cases can be resolved through negotiation or mediation without the cost of court proceedings, but where that's not possible, you may need a clear strategy for court. Finally, some additional advice if you're looking to purchase land or property where you think there could be a risk of flooding. Don't rely purely on a no history of flooding statement. Future-proof yourself by carrying out proper due diligence, checking flood risk information, reviewing drainage infrastructure, and getting expert input where needed, whether that's from your solicitor or from a specialist surveyor. In England, tools like the government's long-term flood risk service can be a helpful starting point. Additionally, if a seller fails to disclose known flood risk or history, there may also be scope to explore a misrepresentation claim. Flood-related neighbour disputes can be complex, and they often involve technical evidence and practical fixes and nuanced legal principles. If you're dealing with flooding concerns or you're planning works that could affect water flow, our property litigation team can help you assess risk and take the right next step.